Hi everyone, my name is Beverly Allen and I am excited to partner with the Pierce County Law Library for their community how-to video series. And this video is on service of process issues. It's also responsive to some of the questions that you've been asking the Pierce County Law Library. So just a reminder, the Pierce County Law Librarians, they cannot give you legal advice, they can give you resources, but they're happy to take your questions, and some of those questions may become the focus of future videos for the How-To Community video series. Also, if you have specific questions or follow-up questions, I have a Facebook page, Tacoma Legal Coach, and you can go to that and message that page and ask your questions. And I'm happy to do live videos. You can see a lot of videos that I've done on different topics that are already on that page. So I've prepared a PowerPoint for you, and I'm going to share my screen here so that you can see it. All right, so if I express an opinion in this video, it is my opinion. It is not an endorsement by Pierce County or the Law Library. Also, keep in mind that rules and statutes do change. You need to make sure that you are doing your due diligence and going to courts.wa.gov/rules to make sure you have the most current rules. If you're looking at the forms, go to courts.wa.gov/forms to make sure you have the most current version of the form as well. So first, this was covered in the last video as far as Civil Rule 4. This just goes over the different types of service of process. For original documents, your summons, your complaint, your petition, those all need to be personally served. Now there's an exception if the other person accepts service. That basically waives all potential service issues. So you'll want to make yourself familiar with that form. And that's addressed in the later slide as well. Also, if you're doing something like you're trying to serve a tenant with a notification of your receipt of the damage deposit or your withholding of the damage deposit, that statute actually authorizes you to simply mail out that notice. If you are relocating, the relocation statute allows you to serve that notice via certified mail. So there are exceptions to personal service, but in general, if it's an original document, it needs to be personally served. 3 and 4 address rare situations. If you cannot personally serve someone after due diligence, then you'll have to ask the court for permission to either serve them via mail if you have an address, and that's my recommended way, or via publication. Publication is typically to be used if you don't have an address whatsoever, or if you don't think that service by mail will be effective. And again, that has to be via court order. Okay, so Civil Rule 5 gets into a bit more detail. After you've already started the case, you're wanting to file and serve documents or pleadings or other paperwork. Well, you can do that on the attorney directly if the attorney has filed a notice of appearance. You cannot serve an attorney for documents that are required by statute or court rule to be personally served unless they sign an acceptance of service because their client has authorized them to accept service. For documents after the summons and complaint, you can serve by mail, but you also need to add 3 days for that. So you also need to file with the court proof that you've served. That can be done via written acknowledgement of the person who is accepting service. It can be done by an affidavit of service, for example, an affidavit of service by mail. Or if you're the attorney and you're serving, you can file the certificate of the attorney. There's a sample, and that's in Civil Rule 5B2B. And then one of my favorite ways of serving is by any means that's consented to in writing by the person served. So this means you have some flexibility. The person you're serving can agree in writing to accept service by, say, Facebook Messenger or some other means of delivery. It does not have to be email. And this, I think, is a nod to technology changes. You can serve files in a variety of formats. So here I've listed some documents that you can file to prove that you've served. Family law, you'll notice, has many different types of documents. This first one, FL All Family 101, proof of personal service, that's for the petition. That can also be used for, say, contempt. Also, family law, All Family 112, that's the proof of mailing or hand delivery. That's a document that you're going to want to use for documents after the summons and petition, such as motions, such as responses, any other documents that aren't the original petition or summons. And then this is a beautiful form, FL All Family 117, service accepted. It clears up any service issues that you might run into. Okay, contempt, I've touched on that before. Contempt is required to be personally served. If someone has changed their address, if you can't find them anymore, you can hire a process server or a private investigator to run a skip trace to find their address. You can also serve them anywhere where they can be personally found. It does not have to be at their home. So I've had people served at the gym. I've had people served at the exchange of the children. If it has to be personally served, though, then you have to have someone who's not a party to the case personally serve it, and that would include contempt. You can't serve contempt papers just by leaving them on the door. You can't serve them by mail, but you do have to either get an acceptance of service or serve it on someone directly. So here's some practice tips. Make sure that you have all the forms that you need. You can get those at courts.wa.gov/forms. Keep in mind, if you need to alter the forms, that's fine. Download the Word version, alter it to match what you're actually doing. And you can use those forms also for other cases. For example, I recently filed a motion to serve via mail on a district court case. I used the Superior Court form and I altered it to make that compliant with the district court. So I changed the caption at the top and I changed some other things about that form. So that's a great website to get started, is that courts.wa.gov/forms. Okay, so the left side of the screen applies to attorneys, the right side applies to self-represented people. And this is concerning Pierce County Local General Rule 30. That governs e-filing and e-service. So e-filing is mandatory for attorneys, left side of the screen. It's voluntary for self-represented parties, but I highly, highly recommend it. And it shows how do you do that. You need to get a Links account. You need to file an e-service registration form in each case separately. So just because you've done it once as a self-represented person for one case doesn't mean that it applies to future cases. For attorneys to change your email address, you need to make sure your information is current with the WSBA. For self-represented people, you need to file a notice of change of address to make sure your email address is current for acceptance of service. Now, there's pros and cons to doing an acceptance of service. And this really only applies to self-represented people because, again, attorneys are required, unless, of course, they get a waiver by the clerk. I can't imagine the circumstances that a waiver would be granted. It's possible, I suppose, but this is probably just going to apply to self-represented folks. Pros are these documents are immediately available. You have a record and links. You can click on them at any time. You know when they were served. They're accepted when they're e-served. It's easier for you to meet deadlines such as the response and reply because you can do that on the same day. You don't have to add 3 days for mail. The cons are it's possible you may not immediately realize that you have been served. If there's problems with your technology or your internet or your account, that could be a danger. So make sure you're checking your Links account frequently for updates on your case. E-service does not apply when a self-represented party is not registered for e-service. It also doesn't apply when a statute or rule requires that a document be personally served, and it doesn't apply for things like discovery documents that are not required to be filed with the court. Also, this rule, PC LGR 30B5D, allows an attorney to ask for a waiver. I would expect that would be very rare, but if a waiver is obtained, then e-service does not apply. So here's some recent questions that everyone's been asking, and if you have further questions, again, you can call the law library or you can visit Tacoma Legal Coach and submit your questions there, and I can answer them for you. You don't have to get someone else to mail the documents. Once you've mailed the documents, you can send those out yourself. You do, however, have to get someone else to personally serve the original documents, so the original petition or the original complaint. You as a party, you can serve the attorney for the other side. That's covered in Civil Rule 5. You can't serve the attorney with documents that are required to be personally served, such as the petition or the contempt motion or order to show cause for contempt, unless that attorney's client has authorized the attorney to accept service. An acceptance of service is a wonderful form that can clear up any service problems with the courts, and that is available at courts.wa.gov. You can visit my website for more information. That's TacomaLegalCoach.com. I also have a Facebook page where you can go and submit questions via the messenger function. Also, keep in mind that Tacoma Pro Bono does free legal appointments, and I also volunteer with Tacoma Pro Bono to do some of those free consultations. If you want more information about the COVID-19 crisis or information, you can go to courts.wa.gov, and you can get a list of closures via court jurisdiction and read their local rules there as well. And just very briefly, since we have a little bit of time, I want to show you the forms site. So this is available at courts.wa.gov/forms. Some of those acceptance of service documents that we talked about are in here. So for example, service accepted, FL, all family 117 is a great form, and it allows the other person or their attorney to agree that they've been served and thus to clear up or waive any service problems. So thank you so much for tuning in. Please send your questions to Tacoma Legal Coach or call and ask the Law Library. Thank you so much for tuning in.